All right, we'll get started. I see we have a quorum. This is the Joint Committee on Criminal Justice Reform. We're here to consider a proposed committee substitute to House Bill 1176. The substitute we're working on for members is LC 295280S. But don't get used to that particular substitute because that's going to change. And as happens with anything with this many moving parts, you're going to have many changes. We've had changes up to the last couple hours. There are a series of amendments that have come in late that I know folks are going to go ahead and want to offer, and they should be in your folders. I know there are a couple more that are coming right now. There they are right now. What I thought I would do before just running through sort of at a high level of what we're doing and why, I just wanted just a couple of sort of procedural housekeeping notes. This bill I said when we was first introduced, this bill is a work in progress. It continues to be a work in progress. I feel like the issues have been narrowed, but we are under a time constraint, so we do have to move the ball forward, so to speak. But it's my assumption that we'll go ahead and have some amendments, some clarifying and good cleanup amendments here today, and then it's my assumption that there'll be, after the bill passes the House tomorrow, that we'll take the break and look forward to some other conversations and consensus around any loose strings that may be hanging out there on this particular bill. Of course, the Senate will go ahead and act. When the Senate acts, it has the ability to amend the bill as well on the floor. We will not be coming back into the Joint Committee pursuant to the House Bill 265, authored by Chairman Neal. So as that occurs and as we go through today and then through tomorrow, if there are any lingering issues that are there, I would encourage interested parties to come forward on paper with those particular concerns, and if there are, to be even more helpful, with particular language to be offered in order for us to have a more efficient, expeditious process, especially for our colleagues in the Senate who will have the bill next, obviously, after consideration in the House. With regard to the substitute itself, we took many recommendations from interested parties from across the ideological spectrum, from the court system, from the judges, from the prosecutors, from the defense lawyers, and the bill is split up into sections. What I will do generally is I'll talk to sections in general, and then if members have any questions, I'll go ahead and do my best to answer those questions. If I cannot, I'll ask counsel, and if counsel cannot, then we may go ahead and call on someone in the audience who's a subject matter expert on it to see, just to make sure we have clarity on it. And I'm really going to hit the larger areas within the bill. Part 2 of the bill, sections 2.1 through 2.4, have to do with drug and mental health court divisions, diversion programs, and county drug abuse treatment and education funds. They're pretty self-explanatory. We heard some testimony from the judge community about making sure that we didn't have an executive level agency coming in and telling them what their best practices were on drug courts and other accountability courts. They'd rather go ahead and act pursuant to peer review, their own best practices and standards put forward by the Judicial Council. That made a lot of sense, and that change was made very quickly after our last meeting. We did increase the fee in Section 2-3 to $1,000 required from offenders who enter a pretrial intervention program. Those fees can be altered with a show of good cause to the prosecuting attorney. We did, in Section 2.4, we direct monies arising from fines and forfeited bonds from certain drug offenses to be placed in the County Drug Abuse Treatment and Education Fund. We had a request from the state court judges to make sure that we allowed those funds to be used for DUI courts. I'll be offering an amendment later on to go ahead and affect that change. In Part 3, we start addressing crimes and offenses. We broke burglary into 3 degrees. And you have a summary, by the way, members, in your folders that I'm looking at also in conjunction with the bill and going back and forth. For our theft crimes, we tried Of course, our theft crimes haven't been updated since 1983. We tried to the best of our ability to maintain a uniform standard on theft crimes, bringing them generally to a threshold of 1,500. There are exceptions to that. In Section 3-2, we did assign a scale according to value. If an item's value exceeded $25,000, the penalty was 2 to 20. The item's value below $25,000 but above $5,000, so 5 to $25,000, the penalty was 1 to 10. And then if it's below $5,000, above $1,500, the penalty is 1 to 5. But in all those cases, as with current law, I understand the judge has the ability to treat those as a misdemeanor if he or she wishes. If it's under $1,500, then it is a misdemeanor. With respect to concerns expressed by the retail community, we did keep the threshold for felony shoplifting to 500. We learned a lot about organized retail crime and how in these situations you have really a truly organized theft syndicate that will go out, fan out across an area, and they will go ahead and take their various pawns and steal to the threshold in a very orchestrated manner, so we wanted to be sensitive to that. In forgery, we broke forgery into 4 degrees that are pretty self-explanatory. I think we moved, if I'm not mistaken, on the substitute to the check threshold was actually moved from 1,000 to 1,500. Is that correct? Okay. And that reflects a new change. On the drug piece, we did go with the recommendation to pursue a weight-based approach on drug prosecutions. That varies depending on the weight of the drug, and of course it varies depending on Schedule 1 and 2, which are more serious drugs. Cocaine, meth, they're all serious, but of course cocaine, methamphetamine, and then Schedules 3, 4, and 5. We did go to a weight-based system to allow for the possibility of a more exacting punishment depending on the weight. It was counterintuitive for us to see that a punishment was 1 to 2 grams was going to be treated the same as 27.5 grams. We allow for a lot of judicial discretion in our drug possession. The way we've addressed the drug possession issue, we have sought to really not tie the hands of our judges. We talk about judicial discretion. This was a good opportunity, especially as related to the recidivist statute on both the second offense and both the fourth offense, or the application of the recidivist statute in drug possession in general, so as not to go ahead and tie the hands of our judges. A concern was expressed by the prosecutors, and a good one, that their only concern on that particular issue, my understanding was that we had decent sentencing ranges, so that judges could look at a second offender, a third offender, and if the hammer had to come down in a certain situation, that the hammer could come down, that the sentences were such that they had that room to work with. They could imprison for a certain period of time, followed by probation. It's a case-by-case basis, as opposed to being locked into a mandatory minimum. You may have some offenders who needed that mandatory minimum. Some offenders may not. Judicial discretion is about allowing the judges the flexibility they need to treat an offender according to his or her situation, what's best for them and what's best for public safety, which of course is paramount. From an implementation standpoint on the drug offenses, it was very important for us to have as seamless a transition as possible. The court system, and more importantly our prosecutors, have been dealing with the current rubric of how they go and prosecute drug cases for a long time. It would be unrealistic and unfair, frankly, for us to go ahead and implement a system that would change how we prosecute drug cases simply like flicking a light switch. It doesn't work that way. So if we were going to go ahead and go to a weight-based system, which we propose to do, it was important for us to go ahead and dedicate the resources necessary and the time necessary for our prosecuting attorneys to have enough time to hire the people they needed to hire in order to go ahead and see how this particular method of prosecution was going to work. Therefore, what we proposed to do in this substitute is to incrementally implement this particular bill. And what I mean by that is we were going to go ahead and implement the Schedule 1 and 2 drugs, the possession weight-based approach, in July of 2013. and then to implement Schedule 3, 4, and 5 in July of 2014. What that would do are a couple of things. Number one, it would give the GBI Crime Lab, and we heard the testimony of Director Keenan, that it was going to cost him X amount of dollars, and he's going to have to go ahead and purchase Y amount of equipment. Well, he needs time in order to do that, and more to the point, we have to go ahead and appropriate that, right? So what this will do is allow the General Assembly the time, the administration the time to work together on the proper appropriations, both for the GBI Crime Lab and for the prosecutors. Why for the prosecutors? Because if you go to a weight-based system, it is necessarily going to take more time for these drug cases to move through the system. That is going to mean more people are going to be necessary in prosecutors' offices. Also, if we implemented Schedule 1 and Schedule 2 substances first in July 13 and then Schedule 3, 4, and 5 in July of 14, that would allow prosecutors a year to see how the system is working, how their interface with the crime lab is going, and how that system is really working. Because as we know, there's sometimes a lot of difference between the words that we put on paper and how things actually occur in the real world. So that was the method behind the approach, the incremental approach to allow for funding and training. July 13 for Schedule 1 and 2, July 14 for Schedule 3, 4, and 5. In sections 4.1 to 4.4, we went ahead and responded to prosecutor concerns regarding the statute of limitations for prosecution of child abuse and lifted that statute of limitations altogether. On the mandatory reporting of child abuse on Section 5.1, we went ahead and expanded modestly the number of mandatory reporters. There was a thought at one time, and this of course is coming out of much of this, the Penn State scandal, frankly, that we saw several months ago, and there was a rush, I think, on the part of some to say that everybody should be a mandatory reporter. And while that may sound good on the surface, what we ended up learning, especially from our friends in the prosecution community, is that you'd end up having a lot of he said, she said situations. You have a lot of people accused who ought not be accused, and that would be counterproductive for the system, and frankly counterproductive for combating child abuse. So what we did is we took a bill previously introduced by Representative Mary Margaret Oliver, expanded on that slightly to go ahead and include additional individuals who would be mandatory reporters for child abuse. There is an amendment. We included also language from Representative Donna Sheldon's, one of her pieces of legislation that's pending. There isn't that piece of legislation, we understand, and having looked at it a second time, is a bit overly broad in one respect, and so we have an amendment that I'll be offering at the appropriate time to go ahead and limit the scope of that, and that'll be self-explanatory when we get to it. In Part 6, regarding creating job opportunities, there are a lot of people, there are a fair number of people who would like to go ahead and get a job in this state, but they have certain things on their record that will go ahead and preclude their ability to go ahead and get those, to get an opportunity to be hired. The popular term is expungement. It's not really expungement. It's really record restriction. And so the question was, the challenge for us was to strike a balance to allow those people the opportunity to restrict those records in certain instances, not across the board, but in certain instances, such as dismissals, acquittals, where the prosecution has not brought a case for a certain period of time, certain limited circumstances whereby that record would be restricted from public view in order for them, in order to provide them the opportunity to be hired. But I want to make this clear for members of the committee: at no time would these records be restricted from review by law enforcement. At no time would they be restricted from review by law enforcement. I think we've had many sets of eyes on that particular section of the bill. There are a lot of moving parts on it. We'll have more sets of eyes on it. I think we've got a pretty tight section on that. But I said to Chairman Neal before the meeting, we're going to reserve the right to have missed anything at this point. And that's what you have to do in a joint committee process in order to forge consensus and really get a good work product by the time we leave town late next week. With Part 7, of the bill, that's what I call the Title 42 piece, having to do with penal institutions. We have the Board of Corrections adopting regulations where evidence-based practices guide decisions relating to preparing inmates for release, and the board will prepare an annual report regarding that information. There's a very important provision about allows notice of sentencing of convicted individuals to be transmitted electronically. That's going to bring us into the 21st century on communication on that issue. That is a very important issue for law enforcement and for our correction system. We do have a graduated sanctions portion. We do have a section having to do with a probationer wearing electronic device as a condition of probation, the completion of a substance abuse or mental health treatment program, and or the ability of the probationer to agree to the imposition of graduated sanctions. We have limited the time that an individual who is in violation of probation spends in a probation detention center to 180 days, excuse me. We make automatic that a probated sentence of more than 2 years be reviewed by the probation supervisor rather than require a chief judge to make a request. And we allow for a probation supervisor to impose graduated sanctions so long as graduated sanctions have been made a condition of probation by the court. I've talked about the effective date of the bill. The most important part of that, again, is our implementation of the drug prosecution system, and more importantly, the weight-based system. That is an overview of the bill. There have been late changes, but they've more than anything been technical in nature, and what I would call, when I work with Ms. Travis, a workability issue. Does a certain section make sense? Is there relation to another section? But again, this is a work in progress. I think we've made a lot of progress, but of course, there's a couple more steps left to go, and we look forward to working both with the Senate and the administration. I will tell you that the administration has lent its support to this substitute. That doesn't mean that they don't think it can be better. Of course they do. So do we. And we look forward to working with them toward perfecting the product. As far as the funding goes going forward, we've secured a commitment from the administration, from Governor Deal, on the funding that's necessary to implement this, especially the drug prosecution piece, into fiscal 14 beginning July 1 of next year, and then of course fiscal 15 beginning July 1 of 2014. I know the governor's very serious about this issue. I know he'll bring everything he needs to bear in order for there to be proper funding at the proper time so that we have a seamless transition into what is a more efficient criminal justice system. With that, I'm going to try to, if there are any questions, I'll try to answer them, and we can march on hopefully to a motion and then some amendments. Mr. O'Neill. I'm sorry. Did you have a... No? Okay. Okay, I don't see any questions. Are there... with that in mind, what is the pleasure of the committee? And the chair will accept a motion. Mr. Neal.
I move to pass substitute House Bill 1176, and I know we have some amendments coming, but move to pass.
We do, and that's House Bill 1176, LC 295280S. Let me call on other members who are there any amendments? Mr. Neal, did you have an amendment? Okay, since your light is on anyway.
Have a couple of amendments that are in the folder, and I have a couple of others that I'd like to look at that I haven't got in the folder. But AM 29019.
Let me make sure all members have that. AM 29. I actually don't have it.
AM 292019.
Oh, I do have it. I do have it. Thank you.
Line 1561, deleting only from line 1561.
And could you just tell us what the motivation or the effect is briefly?
This is an amendment in response to the record restriction piece, the clerk of courts, if I remember correctly.
So it will read, a decision of the prosecuting attorney shall not be upheld.
Shall be upheld only if it is, the DAs actually wanted that only taken out so that I think they felt like that was a little bit overreaching to have only in there, if I'm not mistaken.
I actually read it, I read the line of shall not be upheld in 5280S.
Mm-hmm.
Ms. Travis, do you want to weigh in? Okay. But it should read, a decision of the prosecuting attorney shall not be upheld. Is that is the correct?
Mm-hmm.
Okay. Any objection to the Neal amendment of striking the word only in line 1561? Seeing none, it's adopted. Mr. Neal, you have another one?
I do have another one.
Okay.
AM 292020.
2020.
Revised in line 1527. This is language at the request of the clerks of court to address the restricting in the clerk of court to allow them the opportunity to handle this record restriction in the means appropriate according to each local office, if I remember correctly on this one.
Is there any objection to the Neal amendment AM 292020? Seeing none, it's adopted. Any further amendments, Mr. Neal?
Mr. Chairman, let's look at the other amendments that are here, if that's okay with you, and then there's a couple of questions that I'd like to come back to.
Do you have any other amendments?
Mm-mm.
Okay.
Well, possibly. A couple of things I'd like to look at.
Okay.
Let me look at those a little bit more.
Senator Grant.
I don't have those.
Yes, Mr. Chairman. The amendments that I want to make are...
Let me ask you to pull the mic if you could.
Oh, I'm sorry.
Thank you.
In sections 2.1 and 2.2 pertaining to the drug and mental health courts, on lines 108, after the word review, insert the word peer. That's on line 108. Again, on lines 129, after the words performance, insert the word peer prior to review.
It's, hold on, let's make sure Ms. Travis is caught up. On line 108, after the word review, insert the word peer.
Excuse me, I'm sorry. It's before the word review. So
I'm sorry.
Peer review.
I'm sorry.
I stated that wrong.
I should have seen that. Peer review, line 108.
And then on lines 129, the performance peer review. And then duplicate that in the sections 2.2, and it comes on line 216, where again the word peer is inserted prior to review, and on lines 238, where peer is inserted in before review. And then one final change is on line 234. The words participant, employment, and comma, strike that language, participant, employment, comma.
Can you give us the motivation there?
The motivation there is that many of the folks, this is only pertaining to the mental health courts. We're not striking that out of the drug courts, because many of the folks in the mental health courts have disabilities and are not able to work for a variety of reasons, and the participant employment that particular measure is always going to be very low in a mental health court. So okay. We prefer to have that, I would prefer to have that struck.
Can I ask you, was that as per feedback from?
From the mental health courts, yes it was.
Thank you. Are there any objections to any of the grant amendments? Ms. Abrams.
Thank you, Mr. Chairman. Senator Grant, I understand and I recall the robust discussion. I just want to be certain when we say a certification and peer review process, is that certification granted via the peer review, or is it, are these going to be separate? Because my concern is that if you only have a peer review process without some independent third party involved in it, you remove the independence of the review itself, and you may compromise the evaluation. So I understand wanting a peer review process, but because of how this line is written, it is both certification and review. So if you put the word peer in there, is the certification now being done by their peers?
Well, I understand your concern about the a third party, and I think we do want to have some outside eyes look on any one of the mental health and drug courts. But I do think it's appropriate that we have somebody that does have judicial training that would be able to look at that. So I don't think adding the word peer would be inappropriate even in that setting.
I guess my concern is, are we saying that the certification can only be conducted if it is done by their peers, meaning that no other person can be involved given the syntax that we're using here?
I don't think this is going to apply to the certification. I think it's just the review process that is we're asking to be done by the peers.
If I can ask Ms. Travis to look at that on line 2, where we insert the word peer into the review process, because the phrase is a certification and review process, are we limiting the process to say that certification and review must be conducted by peers? I mean, I just want to make sure we're not creating some limiting factor that we don't intend.
I think by inserting peer there, you're saying the judicial council has to create and manage certification and the peer review process.
But the certification process does not mandate that it be done by their peers?
No.
I don't think so.
Separate.
Okay.
Any objection to the grant amendments? Seeing none, the grant amendments are adopted. Any further amendments from members of the committee? I have a few amendments. One is AM 292017. This goes to the mandatory reporter language, and specifically it applies to the clergy. This was brought to me by the Catholic Archdiocese of Atlanta. The language will on lines 1254 to 1260. It simply clarifies, pursuant to practice, when the mandatory reporting would be engaged and when it would not. Obviously, where our intent is to not interfere with any sort of clerical privilege. And again, it comes from the Catholic Archdiocese at their request. Are there any questions, concerns? Is there any objection to the amendment?
Would you restate that, please?
Sure. This is, I don't know if you have it, 292017. Do you have it there, Senator Grant?
I do not have
It should be
that.
in your folder.
Okay. All right, I got you.
And it really goes to the not making sure that we're not going to require the report. Of course, the whole motivation here is to report child abuse when it's witnessed. However, we don't want to interfere with the clerical privilege, so it would not require child abuse reported solely within the context of confession or other similar communication required to be kept confidential under church doctrine or practice. When a clergy member receives information about child abuse from any other source, the clergy member shall comply with the reporting requirements of this code section, even though the clergy member may have also received a report of child abuse from the confession of the perpetrator. So that's pretty self-explanatory. We're just trying to maintain that balance and not be violative of the clerical privilege.
So it looks like you've just changed one word from religious to church?
No.
Or is there...
Ms. Travis?
The child abuse reported solely within the context of the confession. The language, as
Okay.
I understand it, is clearing up the context of a confession in the Catholic context versus a language that is before you in 2017 with the language that went through the Senate on Senator Unerman's bill, which the clergy works with specifically to make this language a little better, and it didn't make it into 1176. And this is an effort to get the language cleared up for the folks that have it interest in it.
Okay.
Thank you. Any objection to Amendment 292017? Seeing none, the amendment is adopted. This is an amendment that I referred to earlier during the overview, and this is AM 292018. This is to ensure that date funds can be used for DUI courts. Lines 306, 307. Any questions? Any objection to the amendment? Seeing none, the amendment is adopted. The next amendment, AM 292021, also goes to the mandatory reporter language. This is lines 1185 and 1186. And it goes to the definition of reproductive health care facility. And this is not an issue, I want to make sure it's clear, this is not an issue that is getting into the issue of abortion. It simply is getting into where you may have a situation at a reproductive health care facility, including a facility that conducts the abortion procedure. You could very easily have a situation where there is an abuse, a child abuse type situation, and you don't need me to give you an example of that. And what this seeks to do is to include employees of such a facility, if they learn of such abuse, to have to go ahead and report that abuse if, again, they become aware of it. It has nothing to do with anything having to do with the abortion itself. It's simply if they learn about child abuse, nothing more than that. However, in looking at the language in 1184 to 1186, after the words referrals gets into the words contraceptives, contraceptive counseling, sex education, or gynecological care and services. As a practical matter, that could be in a wide variety of locations, not just in a reproductive health care facility. So in an effort to limit the language and not have it be overly broad and overly expansive as it relates, again, just to mandatory child abuse reporting, what I propose is Amendment 292021 that would end the section so it would read, locate on line 1185, location that provides abortions, abortion counseling, or abortion referrals, period, strike contraceptives, contraceptive counseling, sex education, or gynecological care and services. Doctors, of course, are already covered under the mandatory reporting statute. We don't want to, the intent here is not to have it be overly broad, but simply to have a limited, a very focused area of where, if child abuse is learned about, to have as a mandatory reporter. Any questions, Ms. Abrams?
Thank you. And Mr. Chairman, I understand the intent, but I have a concern. The challenge with restricting the language, this is the first time we've defined this term, so it will be the only time this term is defined in our code at all. And by restricting it so dramatically, my fear is that, and I take the gentleman at his word, but my fear is that we are creating a very constrained definition that can be then appropriated for other purposes. And reproductive health care is it is a fairly broad and expansive term for a reason. And so, given that doctors are already covered, abortion counseling, abortion referrals, if there's a doctor in those facilities, they will be covered as of now anyway. So I'm not certain why this language is necessary. If we're not going to cover all of them, I don't think we need to cover any of them, because you're generally dealing with the same people who would be in a hospital. These are services that are performed by doctors.
I appreciate the question. I appreciate the lady's understanding of where I'm coming from and what my intent is here. It really goes to the employees. Doctors are, you're right, doctors are covered, but the employees of a facility, a reproductive health care facility, are not, and that's what we're going, that's the intent behind the inclusion here. But the lady's absolutely right that doctors are already covered. If you look at line 1238, reproductive health care facility personnel and volunteers, those are the individuals that would ultimately be included. And of course, as lady said, the doctors are already included under current law.
If I can follow up.
Sure.
My other concern would be then if you're striking particularly gynecological care and services, we have a number of pregnancy counseling services that serve the same function. An abortion clinic may actually provide the final service, but you often have pregnancy counseling services, and to your point of being able to report that there's some abuse, I think if we're going to speak to reproductive health care facilities, those should include both the abortion facilities but also those pregnancy counseling services, because they have access to the same people. They often have the same type of volunteers. And so I would say either we cover them all or we don't cover any of them, but I'm concerned about creating a restrictive definition.
I mean, if that's solved by including pregnancy counseling,
well, my
then
point,
maybe that would be the way to go.
I mean, my point would be, personally, my preference would be, I think this is and again, I understand the gentleman's intent. My fear is that, as with all things that happen with judiciary, our intent sometimes gets confused later on by others who come back and try to figure out what we intended. And so I would say that at least with regards to AM 29-2021, I would think that it would be better not to adopt this language because I think, to your point, if we include gynecological care and services, that covers pregnancy counseling. It covers any of those services that a girl would be going in for support on.
No, but that's just the point. The amendment seeks to go ahead and if I'm understanding correctly, to go ahead and strike that, so we're not getting overly expansive.
And I'm saying I would rather err on the side of being overly expansive rather than being too restrictive, because if the goal is to say that if a 15-year-old comes in and there is some concern, she may go to an abortion facility or she may go to a pregnancy counseling center. Either of those two places should be responsible if that's how we're going to approach this. And that's just...
I see the lady's point, but would you agree that reference to contraceptives, contraceptive counseling, sex education would be overly broad?
I think that contraceptive and contraceptive counseling should... I would agree that could be stricken, but
okay.
I do think that the larger services...
Okay, then I'll go ahead and I'll amend the amendment simply to offer to strike after abortion referrals, just simply strike the words contraceptives, contraceptive counseling, sex education, so that it would read abortion referrals or gynecological care and services.
Thank you.
Yes, ma'am. Thank you for the dialogue. Would there be any objection to that amendment? Any objection? Okay. Ms. Travis, did you get that? Okay. The amendment's adopted. Any further amendments? Ms. Randall? I'm trying to, okay, got it.
The amendment, looking at line 1206,
Yes, ma'am.
okay. At this point, I was thinking that perhaps we should go ahead and define certain terms. And this, of course, addresses resource centers. Just to make it clear as to the services that are provided and not provided in these resource centers.
I guess my question would be, where is Pregnancy Resource Center referred to somewhere else?
It's not.
Do you want them to provide reporting? You do want them to provide reporting? Okay.
But I thought that this is a good time for us to introduce this and to have it include it as we're defining others?
If I understand correctly, the lady would be defining the words pregnancy resource center, but we don't have that otherwise in the code. I mean, I guess if it's defining it, it's becoming defining for the first time. But then if there's no other reference to it somewhere else, I don't know. Mr. Jacobs.
Let me ask this question of the author of the amendment. Is it the intent to include pregnancy resource centers in the reporting requirement that would be on line 1238?
Yes.
So you have the lead in there from lines 1216 to 1218, and it would then, you want the personnel and volunteers of pregnancy resource centers to be providing reporting as well. All right.
But I don't think the language of the amendment affects that purpose, does it? Or in other words, it defines it, but it doesn't but it doesn't add language to it, assign that duty.
I would be happy to offer a subsequent amendment to amend that language if Ms. Travis can maybe work something up quickly.
Let me go ahead and recognize Senator Crosby.
No, I don't recognize.
Oh, okay. Senator Grant.
I have another suggestion. We'll leave it up to the committee on whether it's included. But on lines 1262, creating job opportunities just seems to be a little much. Shouldn't we just put record restriction there? I'll make that in the form of a motion, put record restriction in place of, and strike the creating job opportunities.
I have no objection to that personally. Ms. Travis, is that problematic? I certainly have no objection to that. Any objection to Senator Grant's amendment 1262, strike creating job opportunities and insert record restriction? Without objection, it's adopted. Mr. Neal, did you have further amendments while Mr. Jacobs is working?
I do have one further amendment. I don't have a copy to pass around, and I apologize for that. I could get a copy if you want me to do that, and we could come back to it. I have the language if you want me to get a copy and come back to it.
How extensive is it?
It's not overly extensive. Let me read it to you, and then you can determine whether you want it on.
Okay.
Line 718, looking at graduated sanctions in Title 42. I would like to strike lines 17 and 18 up to department in line 1720.
I'm sorry, say again?
I'd like to strike after C.
What line number again?
1718.
Oh, I'm sorry.
After C.
Hold on a second. Okay.
After C on 1718 and up until department on 1720. And I'd like to insert the department shall have the authority to impose graduated sanctions in response to a probationer's violation of probation supervision conditions unless the court has expressed an intention in a written order that such violations be heard by the court.
I think I'm going to move to print on that.
All right.
And I'd like Ms. Travis also to have a copy of that if you don't mind, so we can get an idea of the effect on that.
The effect is instead of graduated sanctions being opt-in, graduated sanctions becomes opt-out, basically, is the effect of it. And we can get back to that when we get copies.
And define opt-in and opt-out for us.
Basically, what we would be saying through the legislation is that we anticipate graduated sanctions will be available to the probation officers for those offenders unless the judge sees a reason in this particular case why he would rather it not be graduated sanctions. The way it's written right now, graduated sanctions is only available if the judge so orders. This would make that available unless the judge determined that graduated sanctions would not be appropriate. And with the graduated sanctions, there's with all those graduated sanctions, there's the opportunity for the offender to appeal to a judge and appeal a decision of the probation on those graduated sanctions.
But
I think this will be more effective in what we're trying to do to streamline the process a little bit and give the probation officers a greater opportunity to handle these graduated sanctions. And graduated sanctions, by the way, are not a question of liberty and freedom. They're questions of minor, for the most part, minor technical situations such as curfew violations and those type of things that will allow probation officers to follow a predetermined course of sanctions against those offenders.
But isn't the an effect of that it would ultimately not be the court? Would it? I'm trying to figure out. Again, I don't have the amendment in front of me, but I will. Is it so we would no longer have the court imposing the condition of probation? That it would be determined by the probation officer instead?
This gives the opportunity to deal with sanctions such as increased reporting requirements or verbal or written warnings, community service work crews, treatment or counseling referrals, increased substance abuse testing, electronic monitoring, those type of things imposed within that period of.
Is this the page?
No, this is.
Oh,
I think this one's a different one. Mine's not here yet. Anything that would involve a period of incarceration would have to be something done by the courts. Probation officers wouldn't have an opportunity under graduated sanctions to affect liberty and freedom.
I think I've got to just see the language.
Yeah. Let me, if I could, to expand on this just a little bit. During the hearings of the council frequently heard from various people, including DAs, from what I understand, that probation officers often ignore minor violations and misconduct of probationers because they either ignore those minor violations or they take those minor violations before a judge. And rather than having to take those minor violations back to court, graduated sanctions give those probation officers an opportunity to handle those minor violations. And the bill that we have allows those graduated sanctions, but what my amendment's doing is saying that it would be the normal procedure or process would be graduated sanctions. Unless the judge ordered that with this particular offender he or she didn't want to see graduated sanctions with this offender. The longer
Do we have that language coming?
it's on the way.
Okay.
The longer misconduct goes unchallenged, the more likely the misconduct continues. Graduated sanctions allows a quick response to those minor violations. And with that quick response to minor violations, you have a better outcome, a better opportunity to redirect the behavior than having to go back and go through that process again before the judge under minor violations, allowing those minor violations, that conduct to continue for an extended period of time and increasing the likelihood of recidivism.
Okay. While we're waiting on that language, we do have language from Ms. Abrams.
Actually, I think Mr. Jacobs is
I do.
Okay. Are you 23, Mr. Jacobs?
Okay.
Okay. Yes, you are.
Mr. Chairman,
Oh, sorry.
Mr. Chairman, in talking with Representative Randall about her amendment, I mean, the intent of her amendment is that that there are other service providers where it would make sense to not unfairly single out some service providers, but to add in this other category of service providers to the reporting requirement.
Okay.
And I actually agree with that. So I think with a modification, and I'll state the amendment to make it real clear, with a modification of I'm going to state a modification of Representative Randall's amendment and put it out there for the committee's consideration.
All right.
All right, and that would be to take the language that Representative Randall has here as paragraph 11. Pardon me? No. Okay, that would be the language that Representative Randall has here as paragraph 11. Instead of inserting that as paragraph 11, insert it between lines 1183 and 1184 as a new paragraph 7, and then renumber accordingly, because that's where it would go in alphabetical order. Then on line 1238, you would insert after reproductive health care facility or pregnancy resource center, so that provision would read reproductive health care facility or pregnancy resource center personnel and volunteers.
All right. Let me make sure Ms. Travis has got that. You've got it. Discussion on the amendment? Discussion on the amendment. Ms. Abrams, I need 9. Thank you. Senator Grant has asked for the AG's office to offer an opinion. I certainly have no objection to that. Ms. Westmoreland, do you mind just putting you on the spot without any fair warning?
The language that Representative Neal is talking about, I believe, is...
No.
Well, I think we're...
I'm sorry.
You're on the Randall Jacobs amendment, is that right?
Which one? Okay, which one?
No. You're on Mr. Neal's
Okay.
amendment.
Well, Randall Jacobs, I have no opinion on that.
All right.
Much appreciated, Ms. Westmoreland.
It's a wonderful amendment.
All right, Mr. Jacobs. I want to make sure that Ms. Travis has got the nature and the language of the Jacobs-Randall amendment, the Randall-Jacobs amendment, excuse me. Travis, I don't want to proceed unless you're ready to roll. No, it's okay. I want to make sure that you're comfortable from a structural standpoint on the Randall Jacobs amendment. Okay. Any discussion on the Randall Jacobs amendment? Seeing none, all in favor of the amendment signify by saying aye.
Aye.
Opposed? The ayes have it, and the motion is adopted. Mr. Neal, did you want to speak to your amendment?
I'd be interested in hearing from Ms. Westmoreland since she was
Okay, let me make
ready
sure
to go.
Ms. Westmoreland has a copy of the amendment.
She does have a copy.
Okay.
The regulated sanctions language. Absolutely. This language is similar to what was in 1176 to begin with, I believe. We had a lot of discussions in our office and worked with Ms. Travis extensively to try to come up with something that we felt was constitutional and legal in the way of graduated sanctions, and we specifically suggested that it be made a condition of probation imposed by the court. I understand the concern that you want to make this happen more frequently. The concern is if you don't make it a condition of probation, then you are giving the probation officers pretty much carte blanche discretion, and there's been a lot of concern about that. The way the bill is structured currently, it's quite clear the judge can impose it among any number of conditions of probation. I think judges kind of go down the list frequently. Once they say you can have graduated sanctions, then the probation officer can do exactly what you say. A minimum violation, I'm going to send you to drug treatment. Minimum violation, I'm going to send you to X, Y, and Z. You can't go back to jail without going back to the court.
Right.
But as long as the judge says as a condition of probation, graduated sanctions, then the probation officer has the flexibility to do that. But that way the judge knows they're there and has made an affirmative decision. We felt much more comfortable from a legal perspective that that becomes an affirmative condition of probation, not one that's a sort of just happens because it's in the statute. That way the probationer is fully aware of it, has been advised of it at the time of probation by the probation officer, which was our recommendation for moving it the way it is in this bill now.
So it's a constitutional issue if we try to do the opt-in, the opt-out rather than the opt-in?
We have some concerns about the legal and constitutional ramifications on it. We don't want to, you don't want to take provisions away from the court. That's the court's discretion on what the conditions of probation are. And to say that if the judge doesn't say this, then this is a condition of probation, which is effectively what you're saying, then we had some concerns with that. I think it's much safer to say the judge says this is part of it. You're advised at the time of your probation that this is part of it. You sign on to it, you agree to it, and you know that that's out there. And then the probation officer has the flexibility to do it. And I think that this may be an education process with the judges to let them know it's available and encourage them to use it. But I think this way is a much safer way to do it. It involves a lot of legal concerns.
Mr. Chairman, I withdraw my amendment.
Very well, thank you. Are there any further amendments, Ms. Abrams? Nope. All right, so there's, put that aside. Are there any further amendments? Seeing none, any further discussion? We have a motion and a second of do pass by substitute of LC 295280S. All in favor say aye. Aye. Opposed? The ayes have it and the motion is adopted. And we're adjourned. Thank you, ladies and gentlemen.